report. Blue Water Holding, Santa Rosa County Construction and Demolition Debris Facility Permit. Tony.
Yes, Mr. Chairman, the recommendation is for approval of the Blue Water Holding permit to operate and construct a demolition and debris disposal facility off Jeff H. Road in East Milton.
Any members of the public wish to address the board on this matter? Good morning. Good name and address for the record, please.
Thank you. Jesse Rigby, Clark Partington in Pensacola, 125 West Ravenna Street, and I'm here representing the applicant. I'm going to be very brief. And first, with the chairman's permission, I'd like to ask Mr. McGuire to come up to address specifically Commissioner Cole's question concerning capacity on the wastewater stream. I believe that question was raised on Monday.
Yeah, Jerry McGuire, JMA Engineering Services, Pace, Florida. After Mr. Cole the other day brought up about the capacity of the city of Milton to accept flows from the plant, went and met with them, and they have sent an email, which I've since then forwarded on to each commissioner and also to Mr. Blaylock, Mr. Hickson, and all that. So they do have capacity. They're about 80% capacity on their treatment plant. And also they have sufficient capacity and more than we need in order to be able to take our leachate from our field, our pit, to their facility and all. So there is available capacity, okay?
I recognize this has been a contentious issue in the past. And what the applicant has brought to you is frankly an opportunity to resolve the vast majority of this Harris Act lawsuit. It would resolve all the aspects of it that relate to the actual loss of the property right itself if this permit were granted. Just a couple of key points. It meets all of the county requirements. We have the state required permit. We know that the Blue Water facility under today's regulations would be constructed with a liner system, very similar, if not identical, to what you have at the central landfill. I think, all recognize that in the event of any events like Harvey or Irma in this area, there's going to be a significant increased need to C&D capacity. And I would suggest, your decision, of course, that the central landfill for municipal solid waste is a valuable asset of the county, that its airspace needs to be reserved to the extent possible for municipal solid waste. I think there's a recognition generally now, and I know that Commissioner Salter mentioned it, about the grandfathered status. The testimony is clear from your staff. The development order under which this permit would be granted was in force long before the regulation for the well field protection area. I'd also comment, of course, that the borrow pit aspect of the digging of the hole, has an operational permit issued pursuant to the same development order that's issued to Blue Water Holdings. So again, it's your decision today. This does resolve the significant aspect of the case. What it does leave open, and I don't want there to be any misunderstanding, is the issue concerning what could be called a portion of the just compensation damages running from February 2013, when the permit was denied by the board, up until the time the permit is issued. And there are issues on both sides of that would be addressed by the court. But the value of the property, the value of the loss of the property right, which is the right to operate the C&D facility, would be resolved by the granting of a permit. And we'd be happy to try to answer any questions the board might have today.
Mr. Chairman.
Commissioner Parker, you recognize.
Just for clarification in my mind, I understand there's obviously two different entities involved in this property, the entity that retains the right to dig the borrow pit, and then the entity that I believe we're discussing in front of us today that's wanting to operate a construction and debris landfill. I just want to make sure I'm clear on this. Is irregardless of the action today, does that limit the person that's retaining the rights to mine the dirt? You had mentioned an operation, or, you know, that they had a concurrent one. Could they go out there and in essence start mining the dirt off of the property irregardless of what decision's made today?
Yes, sir, they can. Santa Rosa Soils has that right today and and has the operational permit to do so. It obviously makes sense for both to be moved together because there's some work that would have to be done, but absolutely Santa Rosa Soils has that right today.
Thank you.
And with all county permits to do so. Thank you.
Thank you. Vice Chairman Cole?
Thank you, Mr. Chairman. It hurts me in the gut to approve this, but I did have a question, if I might. I was wondering how we got here today. I know that the former county attorney had authorized and opened the door basically for Blue Water to come in and receive this permit. And why that action wasn't taken today or then, that's in turn caused this action today.
I'll try to give you my history. And first of all, Roy Andrews has been uninvolved in this.
Yes,
There's been, and you've been dealing with
this
your
is the
litigation attorney, Bill and Tim Warner, completely. I'll try to give you a very, very brief history. In February of 2013, this board met to consider issuance of the same operational permit you're talking about today. That was denied.
Correct.
About, and I may be off a little bit, about a week or 2 weeks later, February the 20th, I believe, of 2013, this board authorized the ordinance that expanded the wellfield protection area. That ordinance prohibited for the first time construction and demolition pits and borrow pits on this property. Now, obviously, everybody that was involved knows that the commission had been considering the wellfield protection for months up to that point. But when the permit was denied and then the ordinance was placed into effect that prohibited borrow pits and C&D facilities about a week later, 10 days later, then that gave rise to the Harris Act, because at that point the operation was prohibited. So we moved into litigation over the Harris Act under that procedure, and that's where we are today. There's been discovery. There had been testimony from Ms. Cato primarily concerning the vested rights, the grandfathered status under the development order that was issued actually I believe it's 2008 that the development order was issued, and I have a copy of it. Under that development order, there was also litigation relating to Santa Rosa Soils. Now, it's not Harris Act because the Harris Act wouldn't apply to it. As a result of that action, Santa Rosa Soils obtained a permit based on its grandfathered status to dig the hole that was approved by the development order issued to Blue Water Holdings. Now, that's a little convoluted, but that's where we are today.
Thank you.
Okay. Yes, morning. Name and address for the record, Kyle.
Thank you and good morning. I'm Kyle Hawley. My address 5920 Willard Norris Road. I don't want to be, we're not going to spend too much time on here, but I do have a couple of questions, and I appreciate the gentleman's recapping of the history of things, but I do have one question that is asked of me that I'm not able to answer, and I think now would be a great time to try to get that answer. I believe one of the Blue Water permits had expired over the course of the process, this terminology, and then I believe the county adopted the expansion of the wellfield protection ordinances, mentioned by the gentleman, and so I wanted to hear just a little bit more about that. Was there not really a break at that point, or was there really a break? Would you please explain that? Because a lot of people do want to know it. May I stay here?
Yes, I'm curious, is the attorney that's representing Santa Rosa County here today? No? Okay. Come right ahead.
With respect to the extension of the permits, the development order is the permitted issue here that was issued in 2008.
Yes.
okay, under which this permit would be granted pursuant to the development order. That development order has been extended a number of times. It's a non-discretionary extension. It was always extended pursuant to the Florida statute that extends these development orders when the governor issues an emergency declaration for storms that apply to the particular county, Santa Rosa. I've extended that. It's a notice to the county. It's not a discretionary decision by the county commission. That development order runs now until April 2018. It will be extended one more time right now as a result of the declaration of Hurricane Irma, which will extend it approximately another 8 months, simply by giving notice to the county under that state statute. So the development orders are still in effect and legal, and I believe the county staff agrees with that.
I think I understand that and kind of suspected that, so I appreciate clarification. And that question is really more for those folks that are watching and those folks who will ask questions later. So I don't want to spend too much time really on discussion about the water because while many of us are not going to feel great about what's about to happen, it is a time to reward you all for listening and for learning over the course of that period of time, looking at the science, making sound decisions to identify separate policy for pits and, expanding the policy. I think we see that that's the right thing to do. So I want y'all to know that I appreciate that you listened and that you learned and that you, made choices that you felt like were right for the county. So while I feel like the water, the usable life of the water residentially and commercially, the life of that resource has been mostly extended. And there is some chance that there won't be contamination from this C&D pit. My comments are more related to what I would describe as a mediocre implementation of the future land use there. I think there's a higher and better use. There is some consequence. I talked a little bit about it on Monday. I do need to share. I shared with you that about 10 days ago we were asked to put together some property for a company. The landowners that are there are willing to have good, clean business come in there, and that company appeared to be. I did receive a call yesterday from local economic development that there's another company that appears to be even larger than that company looking for property, and I can't disclose too much of the information that was shared with me with regard to the jobs, but it's well over 1,000 jobs. So what we see today really is something that is, it represents a shift in the area, and it represents a shift in our capacity. And while I know that the commission does not really want to be in the land business, we are in the economic development business. And so I would just close with the thought that we continue to pursue excellence. And even after you make the choice that the decision you have to make today, they do the action you have to do today, I would just ask you to check with economic development, check with people in the departments who are responding to the requests from these companies. And if there is any chance left for excellence, I would just ask you to respectfully to consider that. So with that, I just tell you thank you.
Thank you for your comments, Kyle. If nobody else from the public would like to address the board on this matter, I will turn it over to the will of the board.
Mr. Chairman,
Commissioner Lynchard, you're recognized.
at this time, I don't think this is a ministerial act of the board. The requirements for issuance of the permit have been met, and the board doesn't have the discretion to deny the permit. So I would move approval without objection.
I would object. I don't necessarily understand all of that. I wish I did, but can you maybe expound a little bit more on why the board would not need to vote on the matter and then make a motion to approve the item? Do we need to have a formal action to approve this authorization of the permit?
We have to approve the issuance of the permit.
Okay. This is not something that I'm going to be voting in favor of today. I'll be remaining consistent on this item as I have throughout. As I said at the last meeting, I think it's a matter of risk. I know it's not a great option that's in front of us, but this is not something that I can support even though there's no great options here. But I don't know if that means we have to call for a second or however we have to do it, but those are, my positions remained unchanged on this item.
Mr.
Commissioner
Chairman,
Salter.
I second Commissioner Lynchard's motion.
Okay, we have a motion and a second. All those in favor, Commissioner Parker, discussion?
Please, I'll try to keep it short. You know, I hate to go on the record as supporting it either, for all the reasons that have been hashed out for all these years, but I do think it's important to note it. From what council's told us, we could be looking at, I don't want to use exact figures, but definitely more than that $6 million we talked about earlier today to pay if we deny this permit today. So I just want to have healthy discussion, since obviously we're not going to be a unified board, that if I'm in favor of this, the alternative is millions of dollars paid out in a lawsuit that we're currently involved in, and then the question of what services do we cut or what taxes do we raise to pay that millions of dollars. And I don't know that I'm comfortable with that, but I just want to make sure that's all out there, since I mean, basically now we're postured to either we're supporting this and the possible future, and the worst, greatest fear ever is contaminating the well water. You know, I think it's what the huge fear is that is used for the drinking water in Navarre. But the only other option we have are millions and millions of dollars in lawsuits, from what the attorneys told me. So I'm just maybe throwing that out there for Commissioner Lynchard. Could you just clarify for when it says that which board members supported it and didn't, sort of what the alternative is?
Yeah, it's like, at this point, if you went down to the driver's license bureau, you passed the test, you passed the driver's test, but the clerk issuing the license refused to give you the license because they didn't think that you would be a good driver, or that they thought you would get in a wreck down the road. Well, you can't do that. You don't have the discretion to make that call. You've met all of the requirements at this point. The permit's issued. We're already facing a lawsuit for a Burt Harris Act claim for actions that this board took years ago to protect our water quality out in East Milton. And it's a shame that we're here. I don't want to approve this either. You know, I wish we could do all that we can to protect our water quality that serves East Milton and the rest of the county. You know, we had another member of Mr. Rigby's firm was here earlier arguing on behalf of people who want to protect our water quality. So we're between a rock and a hard place at this point, and we don't have the discretion to deny the permit, and that's why I moved approval.
The only, Commissioner Parker, the only two options as I understand them, and the part that I wasn't understanding was the motion for something that I thought you were saying that we had to approve no matter what, and that's why I objected. We do have options. The only options we have, though, are to, one, approve the permit, or two would be to acquire, or three, I guess, you could deny the permit, at which case there's estimated between 8 and 10 million, I guess, or somewhere in that ballpark that could be possibly on the hook for. And then there's the option to possibly acquire the property. And what would that mean? And that's why I'm saying the same comments, or echoing the same comments that I said before. This decision today, in my mind, is about risk. And by approving this today, then we're saying that the risk of a future contamination of our water source is so minimal in your mind and others' minds, evidently, that willing to go ahead and approve it. And I understand the restrictions that are placed on landfills now, and the permitting, and how unbelievably strict these measures are to protect against contamination. In my mind, there is another option out there, and it would be a significant option, but it would eliminate the risk of contamination. And it would require, likely, you got to acquire the property through eminent domain, more than likely, if there's not a reasonable way to purchase the property or if a purchase price cannot be agreed upon. So I'm not trying to get a free ride here today. I've been consistent since I was on the zoning board as a volunteer speaking about the well field protection zone and the amount of research that I've done on this. It's not just that this is a bad decision, it's that in my mind it's not an acceptable level of risk. That doesn't mean that it's not an extraordinary amount of money that would have to be paid. But basically we're saying that we're fine with not paying that money now in exchange for the fact that we would end up paying that money possibly later. I think if there was contamination later, you're going to look at a much higher expense than you have now. So those are my comments on the item. We're still in discussion, but Commissioner Parker?
I'm going to have to ask our resident attorney, Commissioner Lynchard, on this, since the fellow from the brothers firm, I forgot their last name, isn't here. My interpretation is if we were to deny this, we would be liable, even our attorney stated we'd be liable for that sum, somewhere in the neighborhood of 9 to 10 million. But then on top of that, if we wanted to move forward with a purchase, I believe we'd still have to pay that and the purchase. But if we approve it, I know several of us got emails this week from a person involved in that matter that had stated there would be the possibility of selling it. And then maybe that money that would have been used for a lawsuit could go towards acquiring it. I'm just wanting to verify these facts are correct before I vote, that if we deny it, we may have to pay that money and still have to buy it if we wanted to buy it. But if we approved it, then we would have the option to maybe use that money if the board decided to buy it. I don't know, truthfully, if I could be in support of that either, but depending on the cost. But I just, again, I'm only clarifying it because I understood it from the attorney's standpoint. I'm almost asking, I guess, for a statement of fact for the record. I understood what that attorney told me, that, hey, you're either going to approve this today or you're going to pay around $9 million in lawsuits. And so I guess just as a statement of fact for the record, I'm not so much hemmed up, or I guess the question from the risk, and I appreciate it, is the risk of, okay, do we want to look at the citizens right now and say, I'm spending $9 million out of the general fund to pay for this lawsuit, or do we want to say that the risk is basically if we have I guess we think of Flint, Michigan or something, it's probably not even a good comparison, but if something happened to the drinking water in Navarre, we'd probably look back and say, if we could pinpoint it to this one project, we'd look back and say, yeah, that wasn't a good decision. Is that kind of where we're at, just for that, to make sure we're...
Commissioner Lynchard?
We can enter into discussions with Mr. Rigby's client at any time to purchase the property. We can make an offer at any time to purchase your client's property, whether or not we approve the issuance of this permit. Whether or not he accepts that offer is totally up to him. So a third party could enter into discussions likewise at any time to make an offer to purchase the property, regardless of whether or not this permit is issued. At this point, I don't see that we have the discretion to deny this permit. Again, it's a ministerial act. The requirements for issuance of the permit have been met. We can make a stand and say, I don't want to issue the permit, but fact of the matter is, they've met the requirements that the county has in place. So we don't have the authority to deny the permit.
Mr. Chairman.
I don't want y'all to get confused. We recognize that what you need to do is issue the permit. We are asking for excellence post this action. If you are able to speak internally, if you're able to evaluate risks to the water, but more so than risk to the water at the moment. You know, the resource is clean right now. I want you to think in terms of the opportunity that may be lost there. But we want you to do what you have to do right now. It's the right thing. And then we're just asking that if there's an opportunity for excellence in one of those alternatives, we clearly would like to see business there employing a lot of people. So and I appreciate, but we all need to be careful to make sure that we're not confusing the community, because some of them have really watched this. The gentleman does a fine job of explaining the history, you know, and those who will want to corroborate with staff will get consistent answers. So I think as a community, we can understand this whole thing. But today, right now, you need to do what you have to do.
I just want to say, Kyle, that, again, I'm not confused on the matter. I agree with you. I'm just sort of stating the fact, because if we're not going to be unified, then obviously it comes out that it is sort of an option. And now, you know, the last thing you want is headline of, you're the big bad wolf commissioner that supported this, and we had the option not to. So I'm okay with standing on that side of the fence. I just want, when that story hits the paper, it to be clear of the alternative of $9 to $10 million of hard-working property taxpayers' money that would have to go towards that, and it still, ultimately, I don't think would possibly not even stop it. We could still get tied up in litigation. So I just wanted that to be out there if it's not, you know.
Vice Chairman Cole.
Thank you, Mr. Chairman. Through the chair to Mr. Blaylock. Roger, do we have any intention on our landfill to subside or quit taking C&D in the near future or any time in the future, according to the master plan for the landfill?
We do not, but that's a policy decision of this board, but there's no plan to discontinue.
All right, and I say that because, you know, there was something mentioned earlier about our space, reserving our space, so I didn't want to confuse it that may be part of the issue. The other thing that I'm hoping that once this is passed is that there just won't be a requirement for this type of facility. You don't spend millions of dollars to build a facility regardless of the size unless there's a need. And perhaps what we've seen from the current hurricane, you got to count your blessings along with your disasters, but other than Key West, I think in general, with what was anticipated, the destruction all over our state was, and I'm not meaning to play it down, because certainly if it was your home, it was devastating. But I don't think all in all, it was nowhere near what it could have been. And hopefully factors like that would weigh on a business decision for the future of any facility like this. Thank you, Mr. Chairman.
May I have a 2-minute break?
Mr. Chairman, this is the last issue we have. We're in discussion. I will move again to approve the issuance of the permit without objection.
I'm asking for a couple of minutes to think about the decision that I'm about to make, which I feel very strongly about, and try not to be the one on a 4-1 vote. Hearing no objection, the item is moved. That concludes the rest of the items on today's agenda.
Mr. Chairman, excuse me, we had that one add-on. If you would, well, there's one on the back as well. Sorry, we had there was one more item on the back of the agenda and then the add-on.
Tony, would you like to, the action is to allow them use of the Visitors Information Center, is that correct?
Yes, the Escarosa, Florida.
I would move approval to allow the use of the Navarre Visitor Information Welcome Center during normal business hours for the Escarosa, Florida Restaurant and Lodging Association for a drop-off of non-perishable food and water items. Today, the 14th, the 15th, and September 18th. I make this motion without objection. Hearing no objection, the item is moved. Any members of the public Wish,
Mr. Chairman.
engineering services, okay, we have,
There you go.
item number 2, the engineering services for Santa Rosa County Regional Reuse System. Commissioner Parker requested that this be placed on the regular agenda. Do you have any comments at this time? If not, I'm prepared to move the item. Like to move,
Mr. Chairman,
Vice Chairman Cole.
at that time, I had some additional questions as far as the receivables from that, but they've been answered, so thank you, Mr. Chairman.
Thank you for your comments. I would move approval of item number 2 of the engineering services for Santa Rosa County Regional Reuse System without objection. Hearing no objection, item is moved. We now move to the public forum portion of today's program. Any members of the public wish to address the board? Hearing none, seeing none, we are adjourned.